Giving money to your family is one of the most generous things you can do. It's also one of the easiest ways to lock yourself out of coverage that pays for your nursing home years later, right when you have nothing left. This is what we're going to talk about next on Holy Schmidt.
Holy Schmidt!
Picture this. A couple in their mid-70s has about $500,000 to their name. They live comfortably on Social Security plus the income that's generated from $400,000, so they decide to give $100,000 to their family. The reason they want to do it now instead of leaving it in their will is because they want their kids to enjoy it now, and so they gift the money. Through a strange turn of events, the father falls down and hits his head and needs long-term care. The cost is about $130,000 a year. And after 3 years, they have nothing left. Now, there's a program for situations like this. It's called Medicaid, and it's asset-tested based. So if someone has no assets, then they may qualify for Medicaid, and Medicaid does cover long-term care in some circumstances. But in this situation, that $100,000 gift was only 3 years earlier. And because it was only 3 years earlier, Medicaid won't pay for a period of time. Let's talk about that. So the trap isn't about the IRS. The trap's what happens when the same gift is reviewed by Medicaid, or when the same gift carries a hidden capital gains tax bill that lands on your child's tax return years later. 3 completely separate sets of rules. None of them talk to each other, and the people getting hit by them are ordinary retirees doing ordinary things. In order to understand all of these, you need to understand each of these and how they fit together, or don't, as the case may be. First, the IRS gift tax. This is a system that most retirees know. This is the one that they feel very comfortable with, and they think that if the IRS is okay with it, then other agencies within the government must be okay with it too. Second, Medicare long-term care eligibility. This is a completely separate program run by the states under federal guidelines. If you ever apply for Medicaid to help pay for a nursing home or in-home care, this program reviews your gifts going back 5 years. And here's the part that catches people. The IRS gift rule provides zero protection here. None. A gift the IRS would call perfectly legal can disqualify you from Medicaid for months, sometimes years. Third is capital gains. When you transfer an asset to someone that has an appreciated base, they inherit that base and may have to pay capital gains tax later when they sell the asset. The IRS still lets you make the gift, but if you give it to your child, for example, they have to pay the tax on the appreciation just like you would have had you sold it yourself. Let's start off with point number 1, the system that most retirees know about. At least if you've been watching this channel, you know about them. In 2026, the annual gift tax exclusion is $19,000 per recipient. That number was confirmed by the IRS in Revenue Procedure 2025-32. It's the same as 2025. You can give up to $19,000 to an individual without filing a single piece of paperwork, and so the recipient gets the gift effectively document-free. A married couple can give even more. They can give up to $38,000 without filing any paperwork as long as it comes from the couple's own assets, of course. And you can give this gift to as many people as you want. $19,000 each to your 3 children. $19,000 each to your 7 grandchildren. You get the point. You can give a lot of money without any documentation whatsoever. If you give more than $19,000, you have to fill out IRS Form 709, which again isn't a big deal usually because the gift tax limitation is $15 million. That form just catalogs it. So if you give less than $15 million, it just reduces the lifetime exemption. Simple as that. But here's where the protection ends. There's another set of rules for Medicaid, and it's completely different. If you ever apply for Medicaid long-term care benefits, and statistically many of you will, the state reviews 60 months of your financial history, 5 full years. Every gift, every transfer, every asset sold below fair market value during that window. The IRS gift protection rule has zero protection here. Medicaid doesn't care whether it was legal with the IRS or not. They don't even care if it was documented because that $19,000 may not have been documented, because you don't have to fill out a form for it. It's still a measurable gift. Here's the math, and this is really important. The penalty for gifts within the look-back period is calculated by dividing the total amount gifted by your state's average daily or monthly cost of nursing home care. This is called the penalty divisor, and it varies by state. Florida's penalty divisor, for example, is $10,645 per month. Pennsylvania, $421 per day. New Jersey, $12,270 per month. So the gift creates a different outcome depending on which state you're in, but the math still works the same. Total gifts divided by the divisor is the number of days or months that you are ineligible for long-term care payment by Medicaid. Now, why does this really matter? Two reasons. The first is that in the example that I gave at the beginning, this was a couple who had quite a bit of money and they had a reversal of fortune and they lost it all. And because they gave part of their money away early, that same amount was a disqualifier for Medicaid long-term care. And the other is that 70% of people in retirement will eventually need some form of long-term care. 20% will need it for 5 years or longer. That's the actual data. And the median cost, $355 per day or $130,000 per year. A semi-private room is a little less. It's $315 per day or $115,000 per year. And the cruelest part of all is that the program doesn't start the measurement the day you gave the gift. They start the measurement when you need the money the most, when you have nothing else left. Let's put the exact numbers on the couple that we were talking about from the beginning. They had $500,000 and gave away $100,000 and kept $400,000. Over the next 3 years, the patriarch of the family's care ran $130,000 a year, and that $400,000 was gone at that point. So they applied for Medicaid. And the state looks back for the 5 previous years, saw the $100,000 gift, and let's say that the cost was $10,000 per month for nursing care or long-term care. That means that the recipient was locked out for 10 months from the program. And to be really clear, usually long-term care isn't something that you can defer until you're out of a 5-year window. You need it when you need it. They somehow need to find another $100,000 to pay for that long-term care for those 10 months, or perhaps have family members help. I don't know. And to be super clear, Medicare doesn't cover long-term care outside of the skilled nursing care we talked about a few minutes ago. Speaking of Medicare, gang, Medicare can be confusing. It can be overwhelming. Ask anybody who's age 65 or older, and they will tell you that this is true. Someone will spend hours analyzing all of the different plans. They'll make a choice, and then they pick the wrong plan, costing them hundreds or even thousands of dollars a year. Now, on this channel, we have 3 affiliate relationships. One is our trusted Medicare partner, Chapter. Chapter is the only national advisor that looks at and recommends every plan. They're totally free to you. It doesn't cost more to use them. They save their clients an average of $1,100 per year. They're really easy to work with, and a review takes about 20 minutes. If this is of interest to you, give them a call at 440-703-1224 to see if they can help. Now let's talk about the third trap. This is the capital gains trap, and it's one of the most expensive traps I've seen in my years as a CPA. Now here's the rule. When you gift an asset to someone, a child, let's say, the original basis transfers with it. Stocks, real estate, a business sometimes. Whatever the basis is, it goes to the new owner of the asset. Your child inherits the tax bill. But if the same child received that gift through an inheritance, the basis steps up and they don't have that tax bill. Under Internal Revenue Code Section 1014, which remains the rule under current law, your child's cost basis resets to the fair market value on the date of your death. Assuming that the asset hasn't appreciated further, your child can sell the asset and have zero tax owed on the asset. Let me show you how the math works in real life. Let's say you bought a stock for, say, $20,000 30 years ago. Today, that stock is worth $300,000. There's a $280,000 capital gain on that stock. If you give that stock to your daughter while you're still alive, she takes it with your $20,000 cost basis. If she sells it for $300,000, she owes capital gains on $280,000. At 15% long-term capital gains rate, that's $42,000 in federal tax. At 20% for higher earners, it's $56,000, plus state taxes in most states. If you leave that same stock to her through your estate, the basis steps up to $300,000. If she sells it for $300,000, she owes zero taxes on it. That $280,000 of growth for capital gains purposes simply disappears at the moment of inheritance. Same gift, same recipient, same dollar amount, but tens of thousands of dollars less in taxes because it was given as an inheritance, not as a gift. There is one critical exception, and I hear about it on the channel all the time because people get this confused, that step up in basis doesn't apply if it's a 401k or IRA. For a lot of you, for most of you, I would say, this is your largest asset outside of your house, perhaps. The money in those two assets, a 401k or an IRA, weren't taxed on the way in. And so when the assets transfer, whoever receives those assets pays ordinary income when the money comes out. Now, there's one bright spot here, and most retirees never use it. The long-term capital gains rate of 0% applies to single filers with taxable income up to $49,450 and married couples filing jointly up to $98,900. Many retirees, after they retire but before required minimum distributions kick in, are sitting in that 0% long-term capital gains bracket. But here's the part that you should also pay attention to. That gain also counts towards the numbers that I just gave you, the $49,450 and $98,900 respectively. So if you sell a measured amount in the years where your income is low, you can keep yourself in that 0% long-term capital gains bracket. The embedded gain disappears, the carryover basis disappears. You still have the Medicaid problem though. This is one of, if not the single most underutilized strategies in gift giving, but it does require you to know your brackets in the year of sale. So how do you help your family without triggering any of this? First, when it comes to gifting, there are some unlimited exclusions. You should talk to an attorney to see how your state interprets these rules when it applies to Medicare, because state Medicare rules can vary even if IRS treatment is clean. The first is tuition. Under IRS Code 2503E, you can pay tuition directly to a qualified educational institution for someone else with no dollar limit. This doesn't count against your $19,000 exclusion, and it doesn't count against your lifetime exemption. The payment must go directly to the school, not through the student. The same also applies to medical costs. If you pay for those directly, you have the same exclusion. The 0% capital gain strategy. If you're single and your income is under $49,450, or if you're married and your income is under $98,900, you can sell the asset yourself and pay 0% capital gains. Then you can gift the cash and they won't pay tax on it, and you didn't pay tax on it. Just remember that the capital gain itself also counts towards those ceilings that we just talked about. As far as the Medicare 5-year rule, most people are healthier when they're younger versus older, so gifting earlier may or may not be the right move if you want to gift early. If you've already made gifts within the last 5 years and you're approaching an age where long-term care might become necessary, talk to an elder law attorney now. Tools like Medicare Asset Protection Trusts can help mitigate exposure, but they require time. So before you gift, ask yourself 3 questions. First, what does the IRS think? Second, what does Medicare think? Third, what is the long-term capital gain impact? Second, if you're giving cash, taking it from your brokerage account is often a better move than taking it from an IRA because that becomes taxable income. Third, if you're holding an appreciated asset like real estate, for example, that might be something that you should consider for inheritance rather than a gift. If you like this video, check out that video. Here's what you can now do at age 70. Also, if you have questions about Medicare, don't forget to call our partner chapter 440-703-1224 to see if they can help. This is Jeff Schmidt, and I will see you in that video right there.